So I've received these questions from Shivani. I'll start with the first one. So there is a problem that people are facing with Order 8, Rule 4. Should I read it to you?
Yeah, please.
Okay, this one is evasive denial. There was difficulty reading actually 3, 4, and 5. 3 is denial to be specific, then is evasive denial, and then specific denial. So I'll read evasive denial. Where a defendant denies an allegation of fact in the plaint, he must do so evasively, but he must not do so evasively, but answer the point of substance. Thus, if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received. And if the allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances.
Okay. So actually the example is pretty clear, right? When a statement is made that, let's say, for example, due to a typographical error or some calculation error, a person got the sum of money wrong. Okay. Now, if you just simply say that I didn't get so much money, that's not good enough. That would constitute an evasive denial because you're restricting. The point is, he says, and as lawyers, when we draft also, good drafting means you draft this in 2 parts. So you would, in one paragraph, say that he was advanced a sum of money X, and then in the second paragraph, you would say that this was the sum of money. So that way you force the person to commit to the fact that they will take a stand that they didn't get any money at all. But if you are a defendant and somebody says that the defendant borrowed the sum of rupees 25 lakhs 400 from me, just because the sum is not 25 lakhs 400 but 24 lakhs 900, does not mean that you will get away by saying that I did not borrow any sum of 24 lakhs. Now, practically, I'm telling you that a lot of judges also do not understand this as a practice of evasive denial. So you have to point it out to the judge specifically, if you are the plaintiff, to say that, listen, this is an evasive denial. So here there is a tacit admission that he's not received an X amount of money, but he has received some Y amount of money. Are we clear on this?
Ma'am, fairly clear, but ये जो last में एक और इसमें part जोड़ा गया है, I'll read it again. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. What does this mean?
So, for example, if let's say an allegation is made where there are multiple circumstances which can apply, and you take 1 or 2 of those options and you leave out the rest, that's not an okay denial. You have to specifically say that the particular act, you cannot say that this particular act did not happen in this way. I did not kill him with a gun. The denial you have to make is I did not kill him. Okay. You may not have killed him with a gun, but you could have killed him with a knife or with poison or by hitting him on the head with a telephone pole.
Right, ma'am. Right,
So,
right.
just because you've said something in a very limited radius, is not a sufficient denial.
Okay, got it.
So you have
going
to
on-
deny the underlying factum of what you're not supposed to have done, not the factum of I did not do it in this circumstance, which then leaves the field wide open to say that you did do it in some other circumstance.
Right.
Now, as
And-
lawyers, I have to tell you that practically speaking, when we deny things, we of course will utilize this proposition. Because as a person who is denying and who does not want to admit to something, of course, it's my job to do this and I will do it. I will use an evasive denial if I don't have an option, right? It is for the plaintiff's lawyer to catch hold of that omission. So if you're the plaintiff's lawyer, this clause is very important for you. Sorry?
Ma'am, there was some glitch. Yeah. Continue,
Okay.
please.
So what I'm saying is that if you are the plaintiff's lawyer, this is very important for you. Because you will catch on to the evasive denials and you will push them forward to say in your rejoinder that this is an evasive denial. And therefore carries with it a tacit admission that it did not happen in a particularized manner or it was not a particularized sum, but it did happen in some other way or it was some other amount.
Right.
Okay, because as a defendant's lawyer, clearly I will not want my client to tell a lie on oath. That is bad practice. So I will circumlocute. That's my
Right.
job. Right? As a plaintiff's lawyer, it's your job to then catch hold of where I'm trying to be evasive and pin me down.
Right. So what will follow will be additional questioning and additional.
No, rejoinder mein aap daloge na.
Acha, then comes a rejoinder. Right.
Correct. So you have your plaint, your written statement, your rejoinder. In your rejoinder, you will bring it up.
Right, ma'am. Got it. Should I move on to the next rule?
Yeah.
Ma'am, one moment. Ma'am, so if in case the rejoinder doesn't have the required, let's assume the plaintiff's lawyer misses it, can this be brought into the argument later or?
Yeah, surely. Surely.
Thank you.
Surely. Because it's part of your case record, you can bring it up in cross-examination. And you ought to.
Got it, ma'am. Thank you.
कि आपने बोला था कि आपने ये अमाउंट नहीं लिया है, आपने कोई अमाउंट लिया है कि नहीं लिया है? आपने बोला था कि आप वहां पर 25 फरवरी को नहीं गए थे, आप उससे आगे पीछे किसी दिन में गए थे? These
Understood,
are
ma'am.
all questions that you can ask.
Got it. Thank you.
Should I move on, ma'am?
Yeah.
Okay. Specific denial. The rule reads: every allegation of fact in a plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleadings of the defendant, shall be taken to be admitted except as against a person under disability. I think this is fairly simple. Provided
इसका
that
हमने लंबा चौड़ा explanation भी दिया था in the class, if I remember correctly. So
Yeah,
the
we discussed
point
this
is
before.
that every single allegation that is made, you must deny it specifically and completely. It is not enough to say that the contents of the para under reply are wrong and denied. That will land you in the biggest trouble possible if the plaintiff's lawyer is smart. Right? So you have to then make specific denials. And in fact, what we do is we put a kind of an omnibus paragraph ki galti se kuch chhoot jaye, to we put an omnibus paragraph right at the beginning saying that every single averment is denied as if set out individually and denied specifically unless it is admitted. Understand? So this
Got it,
is
ma'am.
the only, of course, the only advantage you will gain is that if your client is disabled, it will not apply.
Right,
Hmm.
ma'am.
Okay.
Reading further, provided that the court may in its discretion require any fact so admitted to be proved otherwise than by such admission, where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of the facts contained in the plaint, except as against a person under a disability. But the court may, in its discretion, require any such fact to be proved. Ma'am, here the question was that what kind of disability are we talking about when we talk about Rule 5, Clause 2?
Disability is a minor, for example. A disability is any person who's not legally competent.
Right, and this one is the
in
same.
for the purposes, yeah, unfortunately now that it's become a little wide, this thing, uh, uh, it will also take into account all physical disabilities.
Right, so these will be the same disabilities that we talk about when we read section 678 of the Limitation Act.
Let's read 6 7 8.
Hanji. So these will be the same, ma'am.
Yeah, most.
Okay,
Let's read 6 7 8.
Yeah, just a second. I'll have to fetch out the Limitation Act.
Raghav, I can read them for you.
Yeah, please.
Great, ma'am. I've got a question here.
Yeah.
Ma'am, you said even the physical disability would be included, but how would it be included? Because let's say somebody has a disability of limb, but he's able to comprehend everything what is being written and what is.
See, the problem is that, for example, a visual disability.
Okay.
Yeah. Or a hearing impairment.
Okay.
Now, what courts don't understand also half the time is people with hearing impairment, sign language is completely different from the language that you and I speak.
That's true.
And so the person with disability, unless they are very well used to, if they are hearing impaired, if they are very well used to writing, reading, and understanding written language, their language is incomprehensible to anybody except a person who understands that particular language as a language. Because, for example, they have no pronouns. The sentence construction, according to us, is very haywire. I used to have this message on my phone, and any judge who ever told me that, hearing impaired, हम लिख के question answer करेंगे, I say बिल्कुल करिए, पर आप ये message पढ़िए और हमको बताइए how will you get from point A to point B. इसमें exactly बताया है उसको, उसने आपको exact direction दी है. अगर आप ये समझ सकते हैं तो वो भी आपकी language समझ लेगा.
Yeah.
And it's impossible for a person who doesn't understand how the deaf write to comprehend the directions. But they're absolutely precise. If I unravel them, everybody understands them. But if you don't unravel them, किसी को समझ नहीं आता.
Right.
You see?
Thank you.
Okay. Raghav?
Yeah,
Uh,
Shivani, please go
yeah.
on.
Yeah. So, ma'am, you were asking for Section 6 of the Limitations Act. It talks about legal disability. It says, where a person entitled to institute a suit or make an application for the execution of a decree is, at the time from which the prescribed period is to be reckoned, a minor or insane or an idiot, he may institute the suit or make the application within the same period after the disability has ceased, as would otherwise have been allowed from the time specified therefore in the third column of the schedule. Ma'am, then it has other subsections as well. Do you want me to
No,
read them?
no. Now go to 7.
Yeah. Section 7 says disability of one of several persons, where one of several persons jointly entitled to institute a suit or make an application for the execution of a decree is under any such disability, and a discharge can be given without the concurrence of such person. Time will run against them all, but where no such discharge can be given, time will not run as against any of them until one of them becomes capable of giving such discharge without the concurrence of the others, or until the disability has ceased.
Okay.
Yeah.
So we are clear in section 6 that it refers to 3 kinds of disabilities, which is basically intellectual, developmental, psychosocial. It does not refer to blindness. It does not refer to locomotor. It does not refer to deafness. However, I'm telling you that now, when it comes to prosecution of a civil case, other forms of disabilities also are in the running to get certain reasonable accommodations. Okay?
Right, ma'am. I think, Shivani, we can move on with the questions now. You can pick up.
All right. So, order 9, right? I think someone's mic is
Yeah, muted.
okay. So, ma'am, next question relates to order 9, rules 10 and 11. So, I'll just read out the rules for you. Rule 10 says procedure in case of non attendance of one or more of several plaintiffs. Where there are more plaintiffs than one, and one or more of them appear and the others do not appear, the court may, at the instance of the plaintiff or the plaintiffs appearing, permit the suit to proceed in the same way as if all the plaintiffs had appeared, or make such order as it thinks fit. Rule 11 says procedure in case of non-attendance of one or more of several defendants. Where there are more defendants than one, and one or more of them appear, and the others do not appear, the suit shall proceed, and the court shall, at the time of pronouncing the judgment, make such order as it thinks fit with respect to the defendants who do not appear. So the question is, why is there a differential treatment for the plaintiffs and the defendants?
Okay.
Yeah.
So plaintiffs, basically, please understand something. Plaintiffs go to court because it's a choice. Defendants do not go to court because it's a choice. They go to court because they are dragged there. The plaintiff is the master of their own case. Okay? They will prosecute it in whichever way they will, which is suited to their best interest. They have something to prove. The defendant does not have to prove anything. The defendant has to simply either disprove the plaintiff, whatever the plaintiff is saying, or alternatively put the plaintiff into a situation where the plaintiff is not able to prove what they are saying. Okay? So, burden of proof, onus of proof. This is part of your Evidence Act. Okay? Now, when plaintiffs come to court, they have to satisfy. Remember that in the CPC class, we did I think a long class on what is a common cause of action and what are separate causes of action. उसमें हमने आपको एक judgment भी बताई थी that you cannot come to court with separate causes of action. It's not like, I have to get my tenant out and you have to get your tenant out in 2 separate properties and we decide कि चलो हम इकट्ठा केस कर लेते हैं, all jolly मजा आएगा. ऐसा नहीं होता है, right? I have to institute my case, you have to institute your case. There are 2 eviction cases against 2 separate people in 2 separate properties. So when you have to show the court that you are joint plaintiffs, you come under a common cause of action. Therefore, if some plaintiffs are prosecuting and some are not, then the plaintiffs have a right to say that, look, let the suit carry on even without these people, as if they were present. Right? Now, as far as the defendants are concerned, the defendant's job is to defend the suit. They don't have to have commonality. They can each set up an independent defense. They may not set up an independent defense. They may agree to adopt someone else's defense. So the suit will proceed, notwithstanding the fact that defendants are not appearing. Can you imagine what chaos would be caused? Defendant बोलेगा चलो जी अगर मैंने appear नहीं करा तो suit तो मेरे against decree नहीं हो सकता. ऐसा हो गया तो there will be complete mayhem, ना? So against the non-appearing defendants, let's say a defendant does not come, does not file a written statement, or does not come for cross-examination, their rights are closed. So that's the way suits proceed. Okay. Have you got the difference?
Yes, ma'am, totally.
Okay. Hanji, next question.
Shivani?
I think there is some network issue.
Okay, I'll just move with a question in chat, ma'am. Acha, okay. Shivani need the access to mic.
Yeah, now I have the access. Actually, I was trying to unmute myself, but I was not able to.
Okay, Saga must have just muted everyone.
Yeah.
Guilty.
Okay.
Okay, ma'am. So now the next set of questions is from Mr. Amit Sharma. I hope Mr. Sharma is in the class.
Yeah, he's right there.
All right. So, ma'am, first question is the difference in appeal, review, revision, and reference.
Okay. Did you miss this class, Amit ji? Hello? Am I audible or not?
Ma'am, he's responded on chat. He says that he did not miss, but he did miss the concept, yes.
Okay. So what we're going to do is we're just going to go through the doc again and let's clarify what is missing. Yeah, Shivani, start.
Okay, ma'am. I need like a minute to open up the docs.
Yeah.
Ma'am, can I ask a small query in the meanwhile? I have one in the chat box. Yeah, so this one is, in a suit for declaration in a civil court, senior division, the defendant files an interim application for rejection of plaint under 711. The same gets allowed, resulting in rejection of plaint. This leads to a decree. Now, should the plaintiff approach the High Court or RFA under 96 of CPC or civil revision petition under 115 of CPC?
Okay. So we are just going to be doing exactly this now.
Exactly what, ma'am?
We are just doing review, revision, reference. This is exactly
that, right?
That will get answered over there. But what I do want to say over here is that this is actually litigant led. So at a given point in time, you may have an option to file a review. You may have an option to file an appeal. You may decide to take either one, or you may have an option to file a review or a revision. It is up to you to take the best option that you think best in the facts and circumstances of each case. right? This is not, nobody can tell you what exactly is to be done. That's for you to, you can file for review of the decision also. If there are factual errors or if it fits into the category of review, then of course you should first take your chances at review before you move to a higher court. Right?
Right. Deepak ji, if you have any follow-up, you have the access. Okay, it's clear, I think, ma'am. Shivani, do we have the doc now?
Yeah, we do have. So Order 41 talks about appeals from original decrees. So ma'am, in this we covered Rule 1 and Rule 5. So Rule 1 is about the form of the appeal and 5 is by stay by the appellate court. You want me to read it out?
No.
Then,
Just go to the section on appeal.
okay. Yeah.
Basically, please understand something. We have to understand what is an appeal. What is a review? A review is when you ask the same court that passed the order to go back, look at its judgment, and reconsider it in the light of what you have pointed out in your review petition. A review has a very, very, very small radius. You can only file it if there is an error apparent on the face of the record. Like, for example, today, I was just looking at a judgment where an injunction was refused, and on the face of it, the court refers to a release deed, which does not exist. Now, using that as a fulcrum, the judgment proceeds to dismiss the injunction. So, you have to look very carefully to say, okay, here is an error apparent on the face of this. Is one of the easiest things to look at. That the court has mentioned something which actually is factually incorrect. Or, for example, if, let's say, you have argued that X, being a government servant, has not proved the fact that they gave a particular loan, because being a government servant, they had to clear it from their employer before they could give this particular loan, and they put no such papers on the record. So they're just using some bank transactions to now claim that it is a loan. Okay. Now the court says, no, there are bank transactions, and these bank transactions show, without taking into account, that they were barred from giving this loan as part of their service unless they had declared it. Not having declared it, the loan has not been adequately proved. Now, if this particular argument has been left out of the judgment, you can go back and say, look, this argument has not been considered at all. On the face of it, there is a problem. Are we clear about review?
Yes, ma'am.
Now, if, for example, you do not have grounds for a review, then you can either go in a revision or an appeal, depending upon what is allowed to you within the terms of CPC. Okay? In an appeal, in a first appeal particularly, a first appeal is like a court of first instance. You can go over the entire material again. So RFAs are usually not restricted to points of law. They are open to points of fact also. Okay, the appeal has a very, very wide ambit, right? So most judgments are appealable. A lot of orders are appealable. Some are not appealable. That you will please check your CPC and see, because I cannot give you some sort of a foolproof mantra for every situation. Go to the CPC and it is very categorically stated what is allowed, in which case, and what is not allowed. There are only few sections. They're very comprehensive. Okay.
Yes,
And
ma'am.
revisions are essentially nothing more than a form of appeal. Slightly more restrictive, slightly less radius, but pretty much if you are smart about your drafting, you can get in everything. I have had situations where an appeal has been mistakenly filed and it's been converted into a revision, or a revision has been filed, it's been converted into an appeal. Okay.
Amitji, do you have any follow up?
So, ma'am, in a revision,
Hmm.
can we send the same document back up again, or do we make edits to that document that we submitted in the appeal?
No, I haven't understood that question.
Ma'am, I appealed a particular issue, let's say for topic X, and the court gave me a decision and I want to get a revision done for that. Can I?
No, you can't send the same document, because when you filed your appeal, there were some XYZ transactions that happened, including a judgment. You
it's
will have to take that judge. See, in a revision, what are you challenging? You're not challenging the facts of the case, you're challenging the judgment. You have to challenge, you will put your factual matrix down, of course, for the court to understand what's going on. I don't like this business these days. What lawyers very often do is that they will not put down a factual matrix. They will say the trial court record may be summoned for the factual matrix. I prefer to have every document as a standalone document. You have to learn how to make your pleadings in a sufficiently succinct manner. But then you have to go on to take the appellate judgment apart to say, why is it that this ought to be revised? Just like in an appeal, you take apart the judgment of the trial court. The concept doesn't change.
Got it, ma'am.
Okay.
Ma'am, I have a question.
Hmm.
Like many a times people are confused about what remedy to go for, and they have review, revision, appeal. So is it prudent to go for, consume the remedy of review first, and if it is rejected, then go for revision, or similarly, first go for revision and then appeal, because one of them, it gets,
Yeah, see, the thing is, you have to see what remedy subsumes another. The remedy of review is always subsumed by an appeal. So if you file an appeal, you can't file a review. So oftentimes, if you have the radius to go into a review, smart lawyers will tell their clients that, look, you need to exhaust this remedy, because that's one rung of the ladder which you may miss, or you will miss, if you go into an appeal directly.
right, and the only con that it will have is that it will increase the time of litigation by a month or so, or whatever months.
So more than a month or so, but yeah, it
Right,
does increase the litigation time.
right. Shivani, we can continue.
Okay. So, ma'am, next question from Mr. Sharma is, When and what remedies are available for setting aside decree ex parte against the defendant?
This depends on the facts and circumstances of the case, because you can claim that there was a temporary insanity. You can claim that there was some other problem. I mean, you have to be creative and inventive. Setting aside an ex parte decree is not that difficult. Actually, if you go through a few judgments, you'll get the general drift of it, what people have taken as pleas. I know that in one of my matters, the defendant came up and said, oh, I could not come on that particular day to argue my matter because there was an audit party in my office. And forever that application for setting aside just went on and on and on and on and on. You know, so there can be so many reasons. The reason could be that you were not well. The reason could be that you missed the date because it was noted down incorrectly. So on and so forth. It depends on from what point you've not attended the case, how that decree has been passed. It could also be that, you know, the matter was being handled by your father, and your father passed away and you had no idea about it. That's also another plea that has been taken on several occasions. So it just depends on exactly what the matter is, what your attendance or non-attendance has been, what are the, you know, so these are grounds you have to make.
Got it, ma'am. Any section or order which we can use, or just generic?
No, it's a generic. I mean, the Shivani, just go to the what is the order?
Ma'am, Order 9, Rule 13.
13, correct.
Yeah.
Read Order 9, Rule 13.
Okay, ma'am. So Order 9, Rule 13 says, setting aside ex parte decree against the defendant. In any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if he satisfies the court that the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to cost payment into the court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit, provided that where the decree is of such a nature that it cannot be set aside as against such defendant only, it may be set aside against all or any of the other defendants also. Provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of summons, if it is satisfied that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim.
Are we clear? It's a very wide section. You can go and give whatever reasons you like, so long as they satisfy the court, court will set it aside.
Understood. Yeah, understood, ma'am. Thank you.
Okay, let's go on to the next question.
Yes, ma'am. The next question is, on what grounds can the limitation time be commuted and what provisions to use to get it done?
Commutation of limitation time. This is strictly not a CPC question. But you know, all I'll say is, if you look at your Limitation Act, they've given different reasons. One of those we just read, Section 6, which says that if you're a minor, if you are if you have a psychosocial disorder or you have an intellectual developmental disability, then until that condition is cured, quote unquote, you get time to file the suit forever, right? So that's one ground on which you can commute. Okay. Now, if you're asking me how to compute limitation, then computation of limitation from the date when your last cause of action happened, provided that that last cause of action before it does not have a gap which would render the matter barred by limitation.
Got it. Thank you.
Okay.
Ma'am, I think we have covered the next question. It is, what is legal disability under the Limitation Act?
Okay, I think I remembered that, so I said it. Okay, chalo, theek hai, both are covered.
ठीक है. So, ma'am, we are done with Mr. Sharma's questions. Now, coming on to Mr. Daljit Sodhi. Is he there in the class? Mr. Sodhi?
Okay, that's not a very nice thing to do. If you're not in class, don't send questions.
Okay, Shivani, let's move on with the questions that the other questions that we have. I
Yeah.
think I saw him in the class, but he has left, so I'll just ping him once.
Yeah, please. Okay. So, moving on, we have Order 11, Rule 10. It says, no exception to be taken. No exception shall be taken to any affidavit in answer, but the sufficiency or otherwise of any such affidavit objected to as insufficient shall be determined by the court. So, if you can give an example of this rule.
Look, no affidavit can be thrown out just because you say it's not sufficient. The court will decide. So I'll give you an example. When I joined the practice at a time when we used to give long form affidavits. And according to my father, they were actually rubbish affidavits, because when he joined the practice, then when you gave an affidavit at the time of filing a plaint, you actually had to affirm every single thing you said in the plaint in the affidavit also, right? By the time I joined the practice, we were giving long form affidavits, but we were saying that, paragraph number so and so, so and so and so and so. And the most important facts, we were saying that these facts you will reiterate in the affidavit, which was the basic structure of your case. Maybe not every single fact, but most of the structure of the case. You came to a point where today everybody files these affidavits which just says that I have not concealed anything, and in the verification they gave all the details of the paragraphs which are based on their information, based on their knowledge, and the paragraphs which are based on legal information which is believed to be true, and then they say nothing is false, nothing is concealed, and then the matter carries on, right? So whenever an affidavit is given, it's not for you. You can say that I object to this because it's not in proper form, it is not sufficient, it is not backing up the plaint, or it's not a proper affidavit of it. But it will be decided by the court. It can't be rejected. Okay? Is that clear? Yeah.
Ma'am, there's a question that Mr. Rajkumar Dubey has. Should I give him the mic?
Sure.
Mr. Dubey, you have the access.
Yes, good evening, ma'am.
Good evening.
Ma'am, I have a question regarding the when we are discussing the appeal matter. Is it follow from us to the going through the orders rules? Yeah, directly we have to approach High Court, yeah, in the district level.
देखो बेटा, ऐसा होता है कि when there are certain orders which you can't appeal from, राइट? बट
Yes, ma'am.
अगर उसमें कुछ आपको मटेरियल हार्म हो रहा है तो उसके लिए प्रोविजन है सीपीसी में, राइट? कुछ ऐसे ऑर्डर्स हैं विच यू कैन अपील या उनका रिवीजन जाता है, राइट? तो वो किस चीज में क्या होगा वो टेलर मेक करना पड़ता है आपको अपना फैक्ट्स एंड सर्कमस्टांसेस देखकर, समझ रहे हैं आप? तो अगर आप वो सेक्शन थोड़ा सा पढ़ेंगे तो आपको बिल्कुल क्लियर हो जाएगा कि आप किस चीज में अपील कर सकते हैं, किसमें। बस एक ब्रॉड सेक्शन है, उसमें बहुत सारा उन्होंने दिया हुआ है कि अगर ये ऑर्डर पास होगा तो आप कर सकते हैं, ये नहीं होगा तो आप नहीं कर सकते हैं, फलाना, तो वो एक पूरा बैठकर हम एक लाइन बाय लाइन ऑर्डर तो नहीं समझा सकते हैं, वो सेक्शन पूरा नहीं उसको कर सकते हैं। सो आई दैट्स व्हाई आई सेड कि आप क्लास में मतलब आपको आइडिया हो गया है कि आपको कहाँ, तो आप सिचुएशन बाय सिचुएशन लेके उसको देखिए कि ये हमारा कवर होता है कि नहीं होता है और कहाँ कवर होता है।
Yes, ma'am. I got it. Thank you, ma'am.
You're welcome.
Ma'am, just an idea, it would be order 43, right? Order 43 and section 103
Correct.
for appealable orders. Yeah, so Ubez, you can check out that one. And on that note, all those who have just visited the site, this course has been with the objective, जो मैंने पहले भी कहा कि we have not been trying to give people a fish to eat, but we have been teaching them how to fish. So that is what the course has done. So if you go for the CPC, then you can of course learn a lot about how to go and go around and about reading sections. So आप अपने आप अपना फिर रास्ता निकालते रहोगे. So we can move on to the next question, Shivani.
All right, Raghav. So, ma'am, next question relates to Order 20, Rule 19. Order 20 is about judgments and decrees. So, Rule 19, Sub-Rule 2, appeal from decree relating to set-off or counterclaim. Any decree passed in a suit in which a set-off or counterclaim is claimed shall be subject to the same provisions in respect of appeal to which it would have been subject if no set-off or counterclaim had been claimed. So, if you can explain this sub-rule.
पहली बात तो ये है कि आपको सेट ऑफ और काउंटर क्लेम का मतलब समझ में आता है?
Barely, ma'am.
हाँ,
Slightly.
अच्छा। काउंटर क्लेम is supposing a person X has to take something from you and you have to take something from X, right? X files a suit against you, you file a counter claim against him saying कि पर तुमने तो मुझे ये देना है. Then both suits are tried together and अगर उसका क्लेम ठीक है उसको मिलेगा, आपका क्लेम ठीक है आपको मिलेगा, दोनों का क्लेम ठीक है तो फिर दोनों को मिलके वो एडजस्ट हो जाएगा और सब जिसको जो देना है जिसको देगा, right? That's a counter claim. Now, equitable set-off is something which आपने किसी से लेना तो है, बट आप उसके लिए इंडिपेंडेंटली जाकर सूट नहीं फाइल कर सकते. अगर वो आपसे इस हालात में क्लेम करता है तो अगेंस्ट दैट क्लेम यू कैन रेज योर equitable set-off. The simplest example I can give is कि एक प्रॉपर्टी है, मान लो वो दो भाइयों को मिली जॉइंट नेम में, राइट? और एक भाई उसमें से उस प्रॉपर्टी में रह रहा है और वो जो सारा हाउस टैक्स वगैरह है वो पेमेंट कर रहा है, ठीक है? 10 साल के बाद सडनली दूसरे भाई ने बोला कि भाई मुझे तो मेरा, उसने पार्टीशन सूट फाइल कर दिया, ही सेज कि मुझे तो मेरा प्रॉपर्टी का आधा हिस्सा चाहिए, राइट? तो पहला भाई बोलता है कि भाई देखो मैं पूरा हाउस टैक्स दे रहा था लेकिन आधा तुम्हारी रिस्पॉन्सिबिलिटी बनती है, तो इसलिए तुम आधे की रिस्पॉन्सिबिलिटी लो और मैं आधे की लूंगा, तो ये आधा जो है दिस बिकम्स एन इक्विटेबल सेट ऑफ. अगर उसका भाई पार्टीशन सूट नहीं करता, he could not have claimed this because थ्योरेटिकली उसके भाई ने तो उसको नहीं बोला ना देने के लिए, वो तो अपनी प्रॉपर्टी का आधा हिस्सा बचाने के लिए, बिकॉज इट्स अनडिवाइडेड, ही इज पेइंग द फुल हाउस टैक्स. That becomes an equitable set-off. Counterclaim would be, on the other hand, for example, I am living in my brother's house, right? And while I'm living there, I tell him ki bhai iska to bathroom is very disgraceful, and he writes to me and he says that please you get the bathroom upgraded and I will pay you. And he does not pay. That is a counterclaim. वही चीज अगर आप उसको अपग्रेड कर देते, because for whatever reasons bathroom was broken, something was wrong, whatever, it could have become an equitable set-off. Because उसने आपको बोला नहीं करने के लिए. Right? So this is the difference between a set-off and a counterclaim. Now what this section is basically saying is that if a decree is passed, then it can be appealed, notwithstanding the fact that there is a counterclaim or a set-off which has been decided for or against the defendant who has filed it, as if there was no counterclaim or set-off. Right? So I file a suit. I say that my brother has been living in my property for the last 10 years as a permissive user. Now I want him to leave and I want to take the property over. Correct? So now the question is, what will happen? This is my claim that वो मेरे property में रह रहा था, उसकी एक decree pass हो. अब उस decree को, supposing the court says no, he can't be evicted for whatever reasons, and I want to appeal that decree, right? In normal course, I would have just appealed the decree कि भाई वो रह रहा था, whatever. अब उसके बीच में my brother files a counterclaim and he says, I spent let's say 25 lakhs and I built an addition to the property, which he has to pay me for. Right? Now that's the counterclaim or the equitable set-off, whichever the case. Okay? In that situation, as far as you are concerned, if the decree is against you, you appeal the decree as if the counterclaim or the set-off had not been filed. वो उसकी problem है, वो उसके साथ क्या करता है. आप समझे हैं बात को?
Yes, ma'am.
So, is there any problem? Is there any confusion?
I think it's clear, ma'am. Anyone who has any question about this, you can raise your hand. You'll get the access to mic. Otherwise, we can move on. Shivani, I think we can move on.
Okay.
All right. Ma'am, next question relates to Order 5, Rule 10. Order 5 talks about summons. So Rule 10 is mode of service of summons. Service of summons shall be made by delivering or tendering a copy thereof signed by the judge or such officer as he appoints in this behalf and sealed with the seal of the court. Now the question is, why is it important to give a copy
of the summon?
Yeah.
How else is the person to whom the summon is being served, how do they know that this is coming from the court?
Nee, ma'am, why is the person not giving the original one, or like maybe that is the...
No. Oh, the copy. No, the original summons is deposited back in, the copy is deposited back in the court. Original तो आप उसी को दोगे ना? Just read it again.
Yeah,
Yes,
should I read it? Shivani, I'm reading it.
Hmm.
Service of the
Yeah,
summons
okay.
shall be made by delivering or tendering a copy thereof, signed by the judge or such
One
officer as.
moment. A copy thereof means he's not saying it's not an original. He's only trying to say that this summons has to be served as a piece of paper that has been signed by the judge.
Okay, that's that kind of copy. So tendering a
Yes.
copy. Yeah.
Yes. Not that it's a duplicate. In fact, the duplicate will be signed and returned to the court. नजारत ब्रांच जब बेलिफ को भेजती है तो बेलिफ उसको आपसे साइन करवा कर लेकर जाता है और उसको डिपॉजिट करता है अपनी रिपोर्ट के साथ कि मैं फला दिन पे गया था, फला टाइम पे गया था और मैंने ऐसे इस पर्सन को ये समन्स दिया था, ये उनका सिग्नेचर है, वो सब कुछ लिख कर देता है.
Right, ma'am.
Raghav, should I move on?
Yeah.
हाँ जी, Shivani.
All right. Ma'am, next question is Order 6, Rule 6. Order 6 is about pleadings. Rule 6 is condition precedent. Any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in his pleading by the plaintiff or the defendant, as the case may be, and subject thereto an averment of the performance or occurrence of all the conditions precedent necessary for the case of the plaintiff or the defendant shall be implied in his pleading. So if you can please elaborate this more.
Okay. Let's take a suit for specific performance. What does the section on specific performance say? That the plaintiff, that if a person is ready and willing to perform their part of the contract and the opposite party does not agree, then in a case for immovable property or certain other things, like for example, something which has an intrinsic value of its own, like an heirloom or something like that, you can file a suit for specific performance because these things cannot be quantified in a monetary value. So what are the conditions precedent on you? How do you cross the threshold? You cross the threshold if in your plaint you carry a specific averment that you were ready with the money and you were willing to pay it to the plaintiff, and this was conveyed to the plaintiff or to the defendant, who then neglected to perform his part of the job. तो आपको कोर्ट को ये दिखाना पड़ेगा कि आपने डिफेंडेंट जो सेलर है प्रॉपर्टी का, फॉर एग्जांपल जो मुकर गया है, वो आपने उसको कब अप्रोच किया, उसको कब बताया कि भाई मेरे पास पैसे तैयार है. ठीक है, तो अगर आप खाली बैंक रिकॉर्ड दिखा देते हो, दैट्स नॉट सफिशिएंट. आपने उसको नोटिस दिया कि नहीं दिया, आपने उससे बोला कि नहीं बोला, आपने कुछ कहा कि नहीं कहा. सो जब तक आपके सूट में ये नहीं होगा, आपने ये प्लीड ही नहीं किया होगा, आप उसको कैसे उसको वो करेंगे, प्रूव करेंगे. दिस हैज टू बी सेट आउट क्लियरली एंड इट हैज टू बी डिनाइड इक्वली क्लियरली. एंड यू हैव टू मेंशन कि मैंने ये काम किया, मैंने ये काम किया, मैंने ये काम किया. राइट
Right, ma'am. Ma'am, इसमें end में ये लिखा हुआ है that an averment of the performance or occurrence of all conditions precedent necessary for the case of the plaintiff or defendant shall be implied in his pleadings. Shall be implied in his pleadings का क्या अर्थ है इसमें?
देखो, when you plead, जो भी आप प्लीड करते हो वही आप प्रूव करते हो. राइट
Right.
तो आपको क्लियर कट उसमें कहना पड़ेगा कि हाँ ये कंडीशन तो फुलफिल हो चुकी थी, तभी मैं कोर्ट आया हूं.
Right.
अंडरस्टैंड? That's what it means.
Okay. Shivani, we can move on.
Yes, ma'am. So now we have Rule 8 from the same order. It says denial of contract. Where a contract is alleged in any pleading, a bare denial of the same by the opposite party shall be construed only as a denial in fact of the express contract alleged or of the matters of fact from which the same may be implied, and not as a denial of the legality or sufficiency in law of such contract.
Okay.
So, ma'am, like if you can explain it further.
I'm trying to think of an example. I can't, not at the moment. Because this kind of a thing is best explained by an example.
Maybe we can, ma'am, circle back to the question again.
Yeah, little
And
later.
also,
Yeah, let me
before
try
going,
and think of an example in the meanwhile. Huh?
yeah, and also before going on to the next question, I think we had borrowed an hour from you and we have already consumed it. So if you would want to continue, we can have the questions from participants and then we can close, or we can continue with one or two more questions. जैसे भी आपको
Let's
ठीक
ask the questions from the participants if there are any questions.
लगे. Right. So we have two. One is from Mr. Pratik Tomti. The question is, in case of revision, if that goes to the same judge who passed the order and the judge dismisses that revision giving reason that do not satisfy us, can we file a revision again requesting to be listed
Revision does not go to the same judge. Revision always goes to a higher court. It is review which goes to the same judge. No judge can sit on judgment upon their own decree. So, in fact, in a high court, for example, or even in a lower court, when you file a case and somebody gives a judgment, right? And then the next thing that happens is that an appeal is filed and the person has got promoted. They cannot hear an appeal on the judgment passed by them when they were in that chair. It has to go to another judge.
Pratik, is there any peculiar circumstance that you would want to add to it so that we can have clarity and have it addressed? I've given you the access to the mic. Okay, I think Pratik is not doing well with the tech. Ma'am, I'll ask the other question. This is by Sai Priya. She wants to ask a title of property which has been disputed and decided already by the court of law, now is being disputed over again, and the defendant is the same person, but the petitioner is different. But the title had already been decided. Will it be, will it be taken cognizance of again, and can we get it dismissed on the ground that it has been the title has already been established?
That depends on the peculiar facts and circumstances of the case. Let me give you an example. There is an HUF property. Okay. So the HUF was between the grandfather and before 2005, 3 sons as the co-partners. Right. Now, let's say that one of the grandsons filed a suit claiming that they had a share in the property and they were told no, nothing doing. This is a HUF property between your grandfather and his 3 sons, and this is not an HUF to which you belong, right? So you may, when your share comes as ancestral property, but today you can't claim anything on it, right? Now, that does not prevent after 2005 one of the daughters from filing a claim saying that this is HUF property between my father and the 3 brothers. After 2005, we are also to be taken as co-partners. I, as a daughter, want to exercise my right and claim my share in the property. We are 2 daughters, and therefore, now the property has to be divided into 7 shares. तीन बेटे हैं तो अब प्रॉपर्टी को 1/7 शेयर मुझे दो. Understood?
I think it's understood, ma'am. There's just one question that I want to ask. I've forgotten the order and the rule, but there was something like agar the defendant or the plaintiff or any party out of them fails in the suit that the person is trying to establish, the court will dismiss it, and the cost of proving shall be on the uh, the other party, or the party who is.
No. That's not it. That is a completely different proposition. That's a specific condition in which a notice is given asking the defendant to admit to certain facts. And
Right.
if the defendant does not do so, or the defendant refuses to do so, or then certain conditions will follow.
Yes, right, ma'am. वही. So उसी में मैम cost of proving क्या होगी? मतलब the complete cost of litigation that the plaintiff has to spend.
No. Cost of proving it means अगर उसके लिए किसी witness को आना है और उस witness को diet money देना है, right? या
Right.
कोई commission appoint होनी है, तो
Right.
उस commission का पैसा. So the cost of proving that particular thing.
Okay, so it works like a notice कि the expenses will ensue and you will pay for it if you do not comply right now.
Yes. That if you don't agree, I mean, या तो तुम yes या no बोल दो, right? अगर आप no बोलते हो, then you have to pay for the cost of proving it.
Right, ma'am. Got it. Right. So I think, ma'am, we'll wrap it up here, and thank you so much for the evening.
Very welcome.
And the course that you've done for us, and all those who would want to visit, I have sent the link again, just reiterating that we have covered the whole CPC, actually the relevant parts of the CPC, with judgments and examples by ma'am, like you've already seen in this class. So it's been beautifully covered. If you would like to go through the details, you have the link in the chat box, and you have my number as well, so you can reach out in case there is any query. So I think we'll wrap it up there. Thank you so much, ma'am. We'll see you
You're very
again.
welcome. Yeah, great to see
And-
you.
Yeah, and we'll be troubling you with the DV course and our queries very soon.
Not a problem.
All right. Thank you
Okay.
so much, Ivani.
All right.
Okay.
Thank you, ma'am.
Good
Bye-bye.
night. Bye.
Good night, everyone.